Okay, let's get started. Good morning again. First, I'd like to ask everyone to mute themselves and switch your view to speaker view. Okay, great. Welcome to the NJBIA Human Resource Council meeting, 2021 Business Immigration Update, the new hiring climate under the Biden administration. Brought to you by Connell Foley, NJM, Investors Bank, Association Member Trust, and the NJBIA HR Support Center. I'm Alice Gens, Chief Operating Officer and CFO at NJBIA, and with us today are Neil Dornbaum and Kathleen Paragoy of Connell Foley. Today's presentation is being recorded and will be emailed to you tomorrow along with the PowerPoint, so be on the lookout for those. I'd like to draw your attention to the chat feature. Neil and Kathleen would be happy to take your questions, so get them in as they come to you via the chat section. After today's presentation, we'll have 20 minutes to network with the speakers. So now, without further ado, let's welcome Neil and Kathleen.
Why don't you introduce yourself?
Okay. Good morning, everyone. Thanks for joining. I'm Kathleen Paragoy, co-chair of the Corporate Immigration Practice Group at Connell Foley, with my partner Neil Dornbaum, who will introduce himself in a moment. We have 30 plus years of corporate immigration practice experience. I'm the past chair of the New Jersey State Bar's immigration section and have a great deal of experience working with HR departments with the corporations that we represent. SURE member. I have an undergraduate degree in industrial relations and organizational behavior, so I feel your pain when it comes to immigration. Neil?
And I have the pleasure of co-chairing with Kathleen our Corporate Immigration Practice Group. We're new over to Connell Foley. We both have been in private practice, as Kathleen said, for over 30 years, practicing exclusively with corporate immigration law. I'm a past chair of the New Jersey State Bar's Immigration Section. I'm a past chair of the American Immigration Lawyers Association's New Jersey Chapter. Nationwide, I've chaired the Immigration Committee under the American Bar Association's General Practice Section, and I have been appointed for a decade to serve as one of the ABA commissioners, overseeing both pro bono efforts throughout the United States and lobbying work up on the Hill. So we come to you with a great deal of background and training, and hopefully we'll be looking forward to sharing some of that expertise with you today. Kathleen, do you want to start us off?
Sure. Just as an introduction of immigration. Immigration has been a hot topic in the newspapers for at least the last 4 years under the Trump administration. What you would have seen, though, in the newspapers is a lot of glaring headlines about asylum, deportation, caravans storming the border wall with Mexico, DACA, unaccompanied children coming across the border, and travel bans. And you may think that these kinds of things, although important, maybe don't affect your business. We're going to talk about today how immigration may affect your business in ways that you may not have considered. And that's because the world itself has become much larger. And as that's happened, the workforce has really become much more diverse. Even companies that are entirely domestic and US based are likely to employ foreign national workers. But in America, we are race, gender, color neutral in our hiring, and we may not always be aware of a worker's nationality or culture that may dictate terms of their employment. Foreign nationals are to be treated the same as others in the workforce: hiring, promotion, relocation, business travel, and the opportunities for professional growth. And no distinction should be made, but we have to remember that there is a key difference that requires pre-planning whenever you're going to move a foreign national through the normal employment life cycle: hiring, promotion, reassignment, relocation, business travel, professional development. Foreign national workers are going to require a government clearance or approval to join you initially, and they have limited work authorization, typically 1 to 3 years to start with you. That means that once they start, it may require an extension for them to continue working with you. It may require an amendment gotten from the government if any term or condition of employment changes. They may also require a visa or a waiver if they're going to travel. They may require sponsorship for legal permanent residents to remain here after that initial 1 to 3 year period, and any extensions that authorize them to remain in that non-immigrant status. So the key takeaway here is that a foreign national employee is temporary employee until the employer makes that employee permanent. So then another key question, if we recognize that, is do we even know who the foreign national employees are in the company and whether or not their employment is restricted or subject to conditions and clearances? The next is, if you're not really sure, then how do you find out in a non-discriminatory way? Is this typically something that's revealed to you in an emergent situation? A problem arises, let's say, at the time of an offer. If the candidate requests sponsorship, or at the time of a clearance, whether or not there's a prevailing wage requirement that exceeds the salary that your company has offered in the offer, or at the last minute requiring sponsorship or filing for them to join the company. It doesn't come up when the employee completes the I-9 form. You've already made the hire, you've brought them in, they produce the documents for you, and you say, oh, wait a minute, what is this? Is this person authorized to work? What you're going to see is at that stage that foreign nationals can be authorized to work in a number of different categories, and they all have letters followed by numbers. You're going to see E-workers, that's treaty traders or investors, F1, students, H1, skilled workers like engineers, IT, architects, I's, J's, foreign research scholars or foreign exchange visitors. The K, fiance visa. The L, an intercompany transferee. The O, an individual of extraordinary ability whose work is in the national interest. A P, an entertainer. An R, a religious worker. A TN, that's a Canadian worker coming across the border.
Or Mexican.
Or Mexican, sorry, two borders, as well as EADs. And EADs, employment authorization document, can be in any number of categories. The DACA children. TPS is a protected status for people from Central America. Derivative spouses, someone whose spouse has applied for the green card. So you think, keeping this all straight. When you review the I-9s on an annual basis, if you do that, that's one non-discriminatory good way to figure out who's in your workforce that might need that special attention and to begin that pre-planning process for managing that part of the workforce. It's not something to be afraid of, but something to be aware of.
You know, Kathleen, I think what we should do today is, I think it might be helpful, since we have a lot of people on from various companies, to kind of make this a little more interactive than most of the time where we just talk to you and explain to you what's going on. So one of the things we're going to do today is we're going to do some polling of the audience, because we think that this is going to allow you to not only understand what the issues are, but how they affect you directly and how it affects some of your colleagues in their businesses. So I think the first poll of the audience today, let's see if everybody is awake or if they're all looking at their iPhones and doing things. If you would, what are the main immigration issues that have affected your business? And we have 7 different things there that, again, seem to come up to us in business every day. We would like you to check off as many of those as you have come in contact with. And let's see what we're looking at from the individuals in our audience today. So feel free to check off if you've had any unanticipated requests for sponsorship, if you've had some difficulties in completing that I-9 form, if you've had problems with hiring due to caps and quotas, or prevailing wage problems. Some of the other areas we see are problems with promotions or relocations requiring a filing, or problems with business travel for key employees, and sometimes requests for evidence or denials actually of a petition given the government's high standards. So if you would, check those off. And let's see what our poll is looking at and see what some of our individuals are showing us today. And Jasmine, when you get a chance, maybe you can tell us if we get any results on that. Okay, we're going to move on.
Okay, and
hold on one second. What? We did get. So a lot of individuals have run into a number of the difficulties.
Unanticipated requests for sponsorship. That seems to be the highest and the most annoying.
Well, that's actually tied with problems due to hiring with our caps and quotas.
Okay.
And we're going to deal with those today because that's all something that's very hot with the new Biden administration, particularly because the Trump administration tried to push through a lot of changes in the last few minutes, and those have now been put on hold. So we're going to talk to you about what the H-1 system is going to look like and how the caps and quotas are going to work this year.
Thanks for your response. That gives us a good idea of what to focus on today.
Now, if I could just get our
Now
thing working today.
Okay, we're going to go on to those general areas that you're going to see where immigration issues often arise.
Okay, so let's talk a little bit about what we do as Immigration Counsel and what your Immigration Counsel should be doing and some of the things that will come across your desk if you're involved with HR and foreign nationals. Certainly the first area is hiring of key leaders and our highly skilled technical workers, predominantly in the H and the L categories. We get calls every day with individuals. How long is it going to take? Can we bring this person on? How do we deal with those caps and quotas? And we're on speed dial with regard to I-9 questions and E-Verify questions because it's a 186-page booklet, and understanding all of the requirements is really one of the banes of most of our HR's existence, dealing with the I-9s and making sure they're done properly. Number two is individuals with changes in duties. Again, foreign nationals, as Kathleen indicated, basically anytime you change their title, their duties, their compensation, or their location of employment, you may be impacting their underlying petition. And in many instances, that will require an amendment of some kind to be filed with the government.
And it's interesting because this often won't come to HR. It usually comes through compensation. And compensation may not think to ask HR whether or not there's any displacement or any issue as far as immigration is concerned. Let's say you're a construction company and you'd like to move the fellow from the site in Oklahoma to the site in Texas. Seems all the same to you. It's the same client that you're working with. That's an issue. You're going to need a clearance because the wage structure in Oklahoma is different from Texas. Same thing if you're going to make a normal kind of promotion. The fellow's been working for 2 years in the job and you tap him on the shoulder and say, we'd like you now to manage the job. You've got a computer fellow who's in the tech side and is doing a terrific job in data development and software development. But now you need a manager. Why can't we just make him a manager? Yes, we can, but we need a clearance first from the government.
And certainly one of the biggest changes has been work from home. It's not just that the foreign national can go and work from the home work site without you taking certain additional actions, and those require an additional posting if you're dealing with an H1, or the filing of an amended application if they're moving out of the MSA. So again, if you have a foreign worker in your company, you have to be aware that there are additional requirements that you have with regard to that individual. Also, we've been dealing with business travel outside of the United States, specifically with all of the restrictions that have gone into place with regard to individuals traveling due to COVID. We have retention of individuals. When do you start processing for permanent residents? Can you start processing for permanent residents? Can you get through competitive recruitment with the high number of individuals who are currently unemployed?
And an important thing to remember is just being asked to sponsor for permanent residents does not mean that you have to sponsor for permanent residents. So if someone asks, it's something that you'll make a judgment, you'll make an assessment, but it's not required. So when you get the question, it doesn't mean, oh, stay away from this person, don't hire them, but it might mean some pre-planning is involved.
We deal with corporate reorganizations, mergers, acquisitions, creation of new offices, and having to deal with the I-9s and doing a full review of the individual's status. We deal with maintenance of status, having to deal with extensions of work permits, and that has been a real problem under the Trump administration, given how long the timelines were taking. Terminations, furloughs, and layoffs have been a big issue that you may be dealing with from your HR department. And then we have the two main ones, which is compliance, making sure your I-9s are in compliance, that your E-Verify is in compliance, your H1 public inspection folders, and those perm retention folders. And last but not least, the number of audits and enforcement actions that have increased dramatically under the Trump administration from numerous agencies dealing with the Department of Homeland Security, Department of State, Department of Labor, and the Department of Justice, to name but a few.
And what you may see is that a fraud detection and national security officer comes to your premises unannounced and asks to see John James, who signed the paperwork on the individual, and then to take pictures of your facility and to walk around, etc. That's something that you would not need to comply with immediately. The first thing you would do is sit down and think for a moment, put the person in a conference room and speed dial your attorney. It can all be dealt with. It's not that threatening, but a lot of these things with immigration do feel threatening. You feel like, got to make a decision right away. It's pre-planning. Stop, look, and listen, as they used to say in grade school. Right?
So what did we look at under the Trump administration? What were some of the issues that we've been dealing with over the last 4 years?
The very restrictive on H1s. If any of you hire H1s in the skilled worker category, IT, engineer, architect, software, construction, you're mostly dealing with H1s. The government has made many proposals to change the rules on this, to increase the wage level, to change the lottery system. It's a restricted category. So each year, only once a year can you apply. When you apply, you have maybe a 40 to 50% chance of getting through. They have ratcheted things up so that the lottery rules would be skewing in favor of the more highly qualified people, people with more experience, people with higher salaries. And that could hurt exponentially people who hire at the entry level. And that's what most of the H-1 employers are doing. So those have been very restrictive. The L's super restrictive as far as extensions of the Canadian border. You used to be able to get those routinely. Now you can't. And you have to go in a longer process through the service centers here. Much higher denial rates. F1 students, very restrictive. With COVID, online studies and Chinese researchers were also targeted as things to be avoided. And the government at one point had issued some rules that would have effectively banned the F1 students from returning or from participating in that program if the school had to put them online because of COVID. Travel bans. You now need a special clearance from the government. You could get it either from the Border Protection Agency at the airport or at the US consulate. But it's a weeks-long process. If you've got a key employee who needs to travel between international groups or to come into the United States to do something key and important, you have to plan on a weeks-long process to make sure you get the clearance. Heightened scrutiny. Even if you do apply, the government is encouraging extreme vetting and denials as much as they can. More audits, more restrictions on certain nationalities. There's a certain, almost racist feeling about what the government's doing. And the COVID pandemic has closed US consulates, so it's extended processing times both here and outside. So Neil's going to take us through some of the 400 plus changes that were implemented in the Trump administration. This was a capsule on what they are, and he'll kind of take you through those and identify them.
And that is correct, Kathleen. I mean, there were 400 major changes. We saw under the Trump administration really a transformation of the immigration system in what were broad brush and sweeping ways, but we also saw a tremendous amount of changes on small technical details that had really far-reaching implications. And he basically told us that he was going to take one of the most activist agendas on immigration, and they basically delivered on almost everything that the president had promised on the campaign trail, and almost exclusively through executive fiat and really ignoring Congress, who he had originally pledged to work with. Now, we have a lot of things in play now with the Biden administration, because with the new election, we have a whole host of staffing choices that still need to be filled, which will impact how the agency interprets a lot of the policies that went into effect. In particular, we're looking at BAHA, which is the Buy American, Hire American, versus what the Biden platform is going to be. We have a whole host of new executive orders that have already come down and that we continue to expect will happen over the next 100 days. And we have pending executive agency rulemaking for rules that have already gone into effect. We will need to have new rulemaking to revoke some of those policies.
And what's important to note is, as the Trump administration has done, the Biden administration is undoing with these executive orders. But what the effect is for this year with the HCAP coming up for March is that everything has either been suspended, it will be the subject of future rulemaking, or it's been rolled back. So for this year's H1, none of these things are going to be affecting you. But for next year, this is where pre-planning comes in. It's essential to look at what the landscape is going to look like and plan for those things accordingly.
And a lot of those, Kathleen, really were due to litigation challenges.
Yes.
We had the U.S. Chamber of Commerce and the National Association of Manufacturers, which set aside the H-1B wage increase. We had the Purdue University, which was a summary judgment against the DOL prevailing wage increase. We had IT Service Alliance, which focused on the employer and employee policies, and the short-term placement rules, which affected a lot of the IT industries. And we have a lot of lawsuits still going on all over the United States. And then we add on to that the coronavirus, which really impacted business, workplace disruption, and we had to deal with all of the travel restrictions globally. Jasmine, can you put up our second poll question here? We had a lot of variables. So this question really is going to ask you, did the coronavirus cause you to institute work from home policies or furloughs or wage cuts? And that's going to be interesting because, again, if you had work from home policies, that's going to impact your foreign workforce in a number of ways, making sure that you took all the appropriate actions relating to the public inspection folders that relate to your H1s. So let's give that a moment. Let's see if we get any responses where people did have to institute these policies.
And just to indicate that the activity, a lot of how these things have been rolled back through the litigation and the activist work that groups like NJBIA do is to be applauded. So when an issue comes, you've got the resource here to be able to come back and to collaborate and to see what can you do to move that needle. It can be done. It sometimes feels that with 400 changes and with all the other things that, wow.
So you can see what this shows us is 86% of you who are out there still awake, which we appreciate at this time, did have an impact. So again, if you are responsible for I-9s, for example, make sure that you are taking the appropriate action. You can also reach out to us. We have a very detailed instruction sheet for our employers advising them what actions are required with the changes that have taken place. Let's talk about some of the other changes, if I can get our screen to move properly with us today.
There you go.
So really the big change that we had was BAHA when Trump came in, and that was the Buy American, Hire American. And really what he basically did was he went to all of the agencies and said, look, we are looking for new guidance and rules to protect the interests of U.S. workers in the administration of the U.S. immigration system. And what that did is each of the agencies came back and said, these are policies that we feel are going to protect wages and working conditions of U.S. workers. So they went ahead and prioritized the advanced degree holders and the high wage earners in the H-1B cap, increased wage minimums, toughened the H-1B program. A lot of policy changes went into effect. The no deference rule, which we'll talk about in a few minutes, scrutiny of the end client contract. So if you are a company that uses third-party placement, you were seeing a tremendous amount of requests for evidence and additional proofs that were required where you were placing an individual on those third-party work sites. We saw the reversal of the regular and advanced degree cap lotteries, changing the number allocations, favoring master's candidates over bachelors. And then we saw the really difficult H-1B, H-2B, L, and J-1 travel bans that went into effect last year. And then again, we ended last year with the DOL and the DHS policies impacting wage scales and the H-1B program. And the good news is on January 25th, President Biden did sign an executive order entitled "The Future is Made in All of America" by all of American workers. And this order basically removes the Trump's Buy Administration, Hire Administration executive order.
Now, in spirit, the idea, no one wants to hurt America and impact the terms and conditions of the employment of American workers. Absolutely not. But it ignores the idea that the workforce is largely a composite now. It's not just US workers. A lot of the best and brightest coming out with the skill sets from these universities happen to be foreign nationals. So the idea is to try to find a way to accommodate both to make sure that business advances.
And what we really saw was at the end of last year, COVID really supersized a lot of these immigration policies. It really gave the administration an opening in the name of public health and concern for the growing economic crisis to finish off those last items that the administration had not been able to achieve. And those included the suspension of visas to certain categories of both immigrants and non-immigrants, effectively ending the asylum at the southern border, attacking the F1 foreign student category, and most recently, again, implementing those restrictive policies on the H-1B program. And the bottom line is a lot of these policies that have gone into effect, and we're going to talk about some of those over the next few minutes, are really not going to be able to go away because these are policies that are already in effect and will require regulatory action or legislative relief to undo a lot of these.
So a lot of the work that has to be done, or the work that's going to get done by the Biden administration, is going to depend on what the political will is to do it. There's a lot on the table. COVID, people don't have enough to eat. They're dying of COVID. They don't have jobs. So healthcare, employment, COVID, all kinds of issues that may take precedence. And our fond hope is that there'll be room on the agenda to work on this.
So what are we likely to see? Well, first of all, we're going to see the overturning of executive orders, because that Biden can do immediately, and the same thing with some of the presidential proclamations. And some of that will alleviate some of the lawsuits that are currently out there that we are fighting. We're going to see, we've seen the White House Chief of Staff already issue a memorandum on the executive agencies. Basically, if they have not yet been published, new rules, they're going to be withdrawn and relooked at. And those that have been published, again, which included the H1 and the DOL increase in salary scales, those are going to be postponed and be reviewed, and they will be reviewed through May of this year. So those are some favorable signs. We also have been advised that the H4 EAD rescission is going to take place. That is, they're not going to implement the rule that would have eliminated work authorization for H4s, which affects about 80,000 individuals, predominantly spouses of Indian nationals who are here in the United States. Can we bring up the other poll question here, Jasmine? The rules would have increased the wage. One of the big one that we're going to be talking about that really affects you in your hiring cycle, which is right about now, is these rules would have increased the wage required to be paid and made it more difficult to hire entry-level workers and succeed in getting H-1B petitions. If these rules remained in effect, and we will get through this year's program, but again, they're going to be reviewed through May, would it cause you to hire fewer H-1Bs? We'd be interested to see whether or not some of these restrictive policies still are having an impact on your current hiring and potentially your future hiring.
And the side question to that is whether or not it's even possible to consider hiring fewer H-1Bs. It may be that most of your pool in certain industries is H-1Bs. A fair number are coming out of the schools. Certain industries just seem to gravitate to that. In the US, we perhaps haven't focused as we could have.
Well, that's interesting. Okay, so far that's good, because when we talk about it, some of those increases were substantial. So let's hold that. Let's close that and move over to our next slide.
Mm-hmm. Thank you. That's very interesting.
So what can we expect from Congress? Well, we can't expect too much. Unfortunately, we have not had a major immigration bill. Our last one was in 1986, and unfortunately I was there for that, so you know how old I am now. And we had some changes in the 1990s, and we had some amendments that took us through 2001, but basically since April of 2001, we have not seen any real major comprehensive bill come out of Congress. So can we expect some changes there? Well, the answer is maybe. President Biden has sent an immigration bill to Congress as part of his commitment to modernize the immigration system. He was going to create an earned roadmap for the undocumented individuals, and we'll talk about that in a bit. The bill clears employment-based backlogs, it recaptures unused visas, it reduces lengthy wait times, it eliminates the per-country cap quotas, which would impact Indian and Chinese nationals. It would make it easier for STEM students to remain in the United States. It would improve access to green cards for workers in lower wage categories. It would provide, it would not allow children to age out when they turn 21. It would create some pilot programs and establish a whole number of commissions. The only problem is, will it ever see the light of day? So a bill gets introduced, it goes to committee, and then we'll ever see if it comes out of committee for a floor vote. Then it has to be voted on by both houses. Then because they both vote on different things, it has to go back for a conference, and then it goes back to be voted on again before it ever sees the president's light of day. So it's nice that we have this bill. It gives us something to talk about. We have a number of lobby days up on the Hill. You're free to join your attorneys and organizations that do that. But the question of whether or not this is going to advance and how quickly is anybody's guess at this point in time.
It's good spirited. It's favoring, it's looking rationally at what the workforce looks like. It's setting priorities for people that are skilled workers. It's trying to equalize the wages so there's no undue benefit. And it's trying to benefit children and others who, asylees and other people who are here because they're fleeing some desperate situation, or they're here because their parents had brought them here.
Now, under the Trump administration, the goal was to reduce levels of immigration, both legal and illegal. there was a dramatic increase in individuals being able to come in through Central and South America countries. There was also a significant drop in green cards that were issued between 16 and 19, almost 17%, and also foreign nationals outside of the countries applying for temporary visas coming into the United States also fell by 17%. Both of those numbers are dramatic considering these numbers all occurred before COVID and the restrictions with the consuls being closed. The other area that was impacted, which doesn't necessarily impact businesses as much, is our humanitarian admissions. They have obviously been curtailed dramatically. They've gone down from about 150,000 down to as little as 18,000 in the last year of the Trump administration. The big one, though, is DACA. DACA has about 800,000 individuals, somewhere between 700,000 and 800,000 individuals. So what DACA was is the Deferred Action for Childhood Arrivals. This basically was the outgrowth of the DREAM provisions that Congress did not pass, which would have granted some pathway to individuals who were brought here as young children and have remained in the United States for the better part of the last 20 plus years. That pool is about 700 to 800,000 individuals who under Obama were granted work authorization. And the hope was that Congress would eventually move those individuals into some kind of legal pathway to obtain permanent residence and eventually US citizenship. We are always surprised. There is a large number of individuals working in the United States through your companies under DACA. Almost 50,000 individuals are benefiting under the DACA provisions, granting the work authorization. The Trump administration tried to do away with DACA. We want to know, do you know of any DACA workers in your business or industry?
You would see them in, if you were doing your I-9 review, someone with an employment authorization document. It's an EAD card, looks like a driver's license with their photo on it, and it would have a code on it indicating on what basis they were granted the EAD. Mm-hmm. And the code for EAD, for DACA EAD, is it CO8?
No, it's either 8, 19, or, well, there are 35 codes, so we would have to double check. She caught me off guard there.
Sorry. So but again, you may not even know, but it would be likely to be someone who is on an EAD, usually a relatively young person. You know, they would have come, and college graduate with good credentials.
No, okay. No. Well, but we do have a few. So let's move on now. I think everyone has made their way back in, which we appreciate. And we're still, of course.
I've seen DACA in accounting firms, and construction firms, engineering firms, architecture. So and IT. I've seen it in marketing as well.
Let's talk about some of the changes that happened that you might not have been aware of. One of the changes was the limiting of the visa validity. In 2018, the State Department quietly revised its consular manual to empower the office to limit the period in which non-immigrant visas are valid. So a lot of people that normally would have got a 10-year visitor's visa were only be given a shorter period of time. Same thing was happening with students. Same thing was happening with your H-1s when they went overseas. They might have only been granted 1 year instead of the full 3 years. And what the purpose of that was to allow the administration to have to come back more frequently. It really messed up business travel, but it also allowed them to view your social media, public charge reviews, expanded consideration if you've ever violated your status. And the one thing you need to be aware of is the Department of State was the #1 reporter of individuals not getting paid the appropriate wage scale. So when your client went overseas, one of the things they were asking for was their pay stubs, and they were checking those pay stubs against the labor condition attestation to make sure that the individual was being paid the appropriate wage scale. If they showed up and they weren't, they may not have been granted a visa to come back, or even if they were, you may have had someone do a notice of intent to deny or have ICE come and visit you to visit your I-9s.
And that happened frequently in the computer field, in IT, frequent travelers needing a visa to come back, and then resulting in a request for you, who might not be the employer. You are, employing, you have a contractor on site, but you may be questioned about that.
Last year was a bad year for travel. Obviously with COVID, things started to change pretty dramatically. The first action was the ban on individuals who were traveling in from China. The ban started to move fairly quickly. Mexico and Canada, we had restrictions with individuals traveling across the shared borders. We had all sorts of public health provisions being implemented. We had a proclamation that blocked immigrant families from coming into the United States. We had the suspension of individuals coming in under the H-1B program. So last year was a very, very bad year for individuals who were either here in the United States who could not travel back home to their home countries because of the pandemic, or individuals who had approval notices and were unable to go to the consuls and come into the United States. The numbers were really staggering. We were looking at about 26,000 permanent residents per month who were being banned. And we were looking at blocking of about 167,000 non-immigrants. Those are your H-1s predominantly, and not other non-immigrants who were trying to come into the United States between July and December of last year.
This would have been disruptive to your business if you had someone who was supposed to start a project, if you were in a manufacturing situation where you have a key person who is coming in to run a manufacturing line, or even at some of the executive levels, banned. Completely banned.
And those bans included China, Iran, the Schengen countries, which are pretty much all of the European countries.
Brazil.
We had the pause on international exchange programs that took place in March, which basically were for the Fulbright programs, the international visitor leadership programs. We then had the following bans continued, where they banned all of the J-1s from coming into the United States, and as Kathleen just indicated, the ban on Brazil. And during that time, we had the suspension of routine travel services also occurring.
This was very injurious to universities. Professors couldn't join. Professors who might have gone out to travel were not able to return to teach. Researchers were not able to get visas. Students were not able to return. This was complicated by the online provisions where they were restricting students as well. Very, very restrictive on every kind of industry imaginable, education, as well as everything else.
And that basically the ban for the H-1Bs, the H-2s, the J-1s, the Ls, and their spouses, which went into effect in June of last year, has now been extended all the way through to March of this year, and we'll have to see what happens after that.
Now, even though those restrictions have, even though the consulates have now opened, they're working at about 20% capacity, and there's a backlog of people that wanted to get visas. And so even though things are going to open up again and are opening up again, pre-planning again is required because it's taking weeks or months to get appointments. Appointments that are set by the consulates are being canceled with very little notice. And people are, if they're over there, they're suspended. They can't return. If they're here, they can't get loved ones back in, or employers can't get employees back.
And getting waivers of these exceptions have been extremely difficult. We work with a large number of pharmaceutical companies. A lot of our individuals have been involved with Warp Speed, and individuals who are critical personnel who are coming in dealing with the manufacturing of the COVID vaccines. We're looking at delays of anywhere from a couple of weeks to a couple of months to get the clearances to come into the United States. So even if you qualify for one of the waivers or exceptions to the COVID travel restrictions, it still was not all that easy for you to travel. And the government were only allowing those waivers to be good for 30 days at a time. And therefore, if the individual came in, went back to go to see his family, you had to get another waiver before they could join us. So those have been real difficult to deal with.
The other important thing to remember is it's not just immigration that's shutting these things down. It's the Department of Transportation, the airlines. The special dispensation has to be granted actually from the Department of Transportation and the airline to allow you to board. So it's a combination of needing clearance from the Department of State, which comes from the US consulates outside, goes to Washington, and then the Department of Transportation. So it's very, very complicated. And in order to get a waiver, you would have to prove that there was a national interest available and unserved by you not being able to enter.
And there was some help judicially. We did have the NAM versus DHS preliminary injunction on the travel ban that went into effect since October 1. Basically, the National Association of Manufacturers, U.S. Chamber of Commerce, National Retail Federation, TechNet, and Intrex all sued the government, and they won the ability to have their members be able to continue to process and obtain visas. The only problem was the State Department only partially implemented those procedures, and it was still very difficult even for members of that class to qualify to get the necessary waivers to come into the United States.
Again, that activist stance by organizations similar to yours is what has moved the needle on this.
We had the closure of international offices, which was also important. We had some 20 plus offices that were outside of the United States. Under the Trump administration, they closed 16 of those. Why was that important? Well, we had a lot of our companies were recruiting individuals who were US citizens or permanent residents working outside of the United States. When they were offered a job to come into the United States, they wanted to bring their spouse and children. Well, when we had international offices, we could apply directly for their applications at those consuls, and normally anywhere from 30 to 90 days later, they would have the necessary clearances. Now we have to apply here in the United States for their applications. We could have an 8 to 14 month delay before that would be adjudicated to allow the spouse and the children to come into the United States, which basically forecloses that individual being able to accept the job here in the US. So the closure of the international offices has really had a negative impact. We had a lot of closures for the USCIS, and that was bad because if you had individuals who were at the last stage of processing for permanent residence, those individuals who were looking for promotions or change of jobs really were foreclosed, because with USCIS not authorizing the permanent residence, it may have had an adverse impact on the grant of permanent residence for individuals who were in process.
And also requiring employers to engage in yet another request for extension because the permanent residence hadn't been granted. So additional cost and additional time in maintaining that work status for your employees.
Another thing that happened under the Trump administration is in the past, when we were processing for permanent residents, the last stage, the I-485, generally was being waived for the interview and the individuals getting granted on the paperwork alone. Under the Trump administration, he required mandatory interviews with everyone processing for their permanent residence, which added another year to another year and a half onto the normal processing time for individuals to get their green cards. We also saw the elimination of deference. So what that basically did is it resulted in a much higher rate of requests for evidence and a much higher rate of denials and notices of intent to deny on previously approved applications. Now, and then the amount of, again, denials has substantially increased across all of the major product lines for you to bring in foreign national workers. So that has been very discouraging. We're going to look at the numbers in a minute, I think. And we also saw some changes to the adjustment of status processing. Under the Trump administration, he had proposed that the third stage in the processing for permanent residence, individuals who were filing the I-485 would not be able to file it concurrently with the I-140 petition, which again would have lengthened the entire process for individuals to obtain their green cards. And it also impacts, obviously, their mobility and promotion tracks.
Also, very onerous disclosures required in connection with the public charge rules. People were required to have credit checks, tax returns,
Health documentation,
very, very onerous. That was never required before, and required at the last minute, and time sensitive and very difficult to obtain in many cases. They don't want just your tax return, they want a transcript from the IRS, and credit reports and things like that.
So the good news is again, those provisions under the public charge are being reviewed by the current administration, and we're hoping that those will be revoked. We also saw a lot of crazy things during the Trump administration. We saw the rejection of forms with blank responses. So individuals, if you filed, in particular, the U visas and I-539s applications for asylum, if you did not put NA or if you left blank anything, they would reject the entire application. We also saw the increasing power of the Secretary of Labor. If you got a denial of your labor certification, you would appeal to the Board of Immigration, to BAHA, and eventually BAHA would render a decision, but it allowed the Secretary of Labor to have the power to review and issue presidential decisions over the decision by the Board of Alien Labor Certification Appeals, which really made it more of a political decision. We saw a tremendous amount of enforcement actions taking place. Those were especially the memorandum of understanding between the Department of Homeland Security and the Department of Labor. This type of direct sharing of information, allowing them to look at PERM applications and LCAs and do data mining, was something we have not really seen the administrations doing previously. And we also saw tremendous delays in work authorization. Last year they had ended the contract with the company that had printed green cards and did not replace them timely, and they got a backlog of over 100,000 cases where they had approved the case, but nobody had pressed the button to actually have the cards produced. We've also seen tremendous delays in the normal processing of EADs, going from prior to Trump being processed in less than 90 days to under the Trump administration between 6 and 8 months to get an extension of a work and travel documents. And that really has frustrated a number of categories where the individuals do not have the automatic 240-day extension.
And for employers, that can be difficult. If you have people working on an employment authorization card, the I-9 requires in a lot of these categories that you have the actual card, not a receipt that you've applied for it, or even an electronic approval receipt, the card itself. And that would prevent the employer from employing the individual and then require them to go on either temporary leave or to be terminated.
That happened a lot for the H-4 EADs because it was taking upwards of 10 months and the individual had to stop work when it expired. It did not grant an automatic extension. There were also the requirements for fingerprinting. Fingerprinting has now been mandatory, which again has added another layer onto the processing. The H-4 rescission, again, the good news is we don't think that the H-4 is going to be attacked. We believe that the H-4 EAD is going to be protected under the next administration.
And that's for the spouse of an H-1 holder.
We had the proposed fee increase, which was substantial. The fee increase was going to raise fees on 39 immigration benefits. Some of them were going to increase upwards of 83%. Fortunately, again, litigation ensued, and in October, those new fee increases were halted, and we anticipate that those fee increases will not become effective.
And just to give you a sense of what that was, for a family of 4, would be approaching $20,000 in fees to the government to process an adjustment of status.
Really?
Yeah, it was,
Okay.
it was tremendous, a 4 times increase.
The EB-5 category for investors was substantially impacted under the Trump administration, raising the minimum investment from $500,000 to $900,000. We also saw the investment going from $1 million to $1.8 million on regular investments. We saw students under attack. Unfortunately, university enrollment has been dramatically impacted under the Trump administration. Not even counting what was happening with COVID. There were a whole number of policies impacting F1 students and the additional requirements that employers who employ them during their STEM periods must undertake. There was also additional reviews by potentially having ICE come out and do on-site audits, just like they would do for the H1 and L1 programs. We also had a lot of back and forth that took place under COVID as to whether students could do online studies. That finally was resolved. Another area we ran into significant problems under the Trump administration was the TN classification. There were additional rules imposed on economists, but we also saw tremendous pushback on individuals trying to come in as management consultants, and also L1s trying to come get extensions or renewals at the border for their L1 classifications.
So the easy process as it was using Canadians and Mexicans became much harder. So those one-day processing events that used to occur, no longer so easy.
And that brings us really to the biggest area, and that is what impacts most of your businesses, which is the H-1B category. Back in March of 2017, we had a whole bunch of RFEs dealing with wage levels. We had additional guidance issued that year, but we were able to basically overcome a lot of those. We had the disqualifications of computer programmers qualifying as specialty occupations. We had market analysts facing all sorts of difficulties, financial analysts facing all sorts of difficulties. We had all of the rules dealing with third-party work sites and the amount of additional red tape that was required to deal with the placement of a person on a third-party work site. We had them limiting companies who had offices in multiple locations from filing multiple H-1s. And we had the changes to the lottery in April of 2019, where we now have a registration period that takes place in March. If you are selected, then you have 90 days from the time you are notified of selection in which to submit your H-1 petition. The big change that we had seen was the potential. Well, there were two big changes. One was the denial rates, which had gone from 95% as an approval in 2015, and then under the Trump administration down to 87% with a 35% RFE rate and only a 68% approval rate after you got an RFE. So these were some pretty dramatic numbers for companies who were either filing first-time H-1s or they were filing for extensions of their H-1s. So those rates were quite troubling. And again, we had, trying to rush through before the change of administration, the H-1B policies that would have increased the wage scales dramatically. And those fortunately have now been enjoined. So for those of you who are looking at the upcoming H-1 season, you need to have identified your F1 students, your TNs, your Ls, anyone else that you are looking at potentially doing your H1 for at this point in time. They should be already with your legal counsel so that they are already in queue so that they can meet the March 1st deadline, and hopefully done the pre-planning of reviewing the applications to make sure that the individuals qualify as a specialty occupation. Because again, a lot of the underlying rules have not changed, which is, does the individual's degree relate directly to the services on which the individual is going to be performing? And again, if we just look, given the limited time we have left, if we just look at what the wage scale increases, if they are not rolled back before March, they were substantial, changing level 1 from 17% to the 45 percentile, level 4 from the 67 all the way up to the 95th. Those raise rates were substantial.
The simple way to look at it is that you'd have to pay an entry-level worker the same wage that you would pay to someone with a mid-career, 3 to 5 years of experience, which is just not the going rate for an entry-level person. So it's a challenge.
Just be aware, site visits. They are ongoing. There is a large number of site visits. These are from the Fraud Detection and National Security Office. These individuals will come out unannounced because they are doing the spot check to make sure the individual is working at the location where they're supposed to be on the LCA, and that the individual is getting paid the wage scale that they're supposed to be paid. And again, if you have moved the individual to work from home, they either needed to do a posting on that home premises and you had to update your public inspection folder to ensure that you are in compliance, or under SMAO, you had to, if you move them outside of the metropolitan statistical area, you had to file an amended application. So don't forget about that.
And remember also, even if you don't have any foreign national employees, but if you outsource anything and you have any vendor or contract workers on site, if they happen to be on an H or an L, the government can come on your site and ask about them. Now, the key there is if they aren't yours and they're not your employees, then you would not answer any questions. You would refer them to the employer of this individual, the vendor or the contractor. But it can still happen that you would have these site visits because they're coming to the workplace.
And they reinstituted the Social Security mismatch letters. So if your company is receiving Social Security mismatch letters, that is a highlight that you should be making sure that your I-9s are also up to date. Because the Social Security mismatch is what will in fact bring out an investigation. So again, that's kind of a telling point if you're getting Social Security mismatches, that you want to make sure that you're doing both an internal and external I-9 audit. So bottom line.
Do we want to offer questions?
No, I think so. I think certainly the conclusion for us is in the 4 years that Donald Trump was president, he did dismantle and reconstruct many of the elements of the U.S. immigration system. Humanitarian protections were severely diminished. The U.S.-Mexican border was closed off. Legal immigration experienced a historic contraction. And all of this was accomplished exclusively by the executive branch. Congress basically was pretty quiet. Now, there is no real clear timeline when the immigration restrictions put in place will in fact be rolled back. Because a lot of them were tied to the prior administration's agenda. Under Biden at this point, we're looking, hopefully he's going to undo many of the Trump actions on immigration. But a lot of them are going to take a significant amount of time to undo. The only good news is we do have an immigration bill and we do have an immigration agenda under Biden. Hopefully that will in fact create an earned roadmap for citizenship for those DACA individuals, and also will in fact help the employment-based side by rolling back some of the very restrictive policies that we had faced. We've already seen a tremendous amount of executive actions on immigration. They're certainly well available. We've had the proclamations continuing the restrictions, adding South Africa as a country on the travel restrictions. We had the rollback of the Muslim and bans. We had the discrimination bans, and we've had some of the rollbacks again indicating that DACA will be protected, and again freezing all of the regulations that were in play and rolling back for 60 days and at least till May some of the more restrictive immigration policies that were trying to be pushed through at the last moment. So I apologize that we've had to talk so fast and did not get to a number of the poll questions that we were hoping to do with you, but we certainly appreciate your time and we appreciate you hanging in there and being a little bit more interactive. And we will look forward to being able to answer any questions that you may have while we move into the networking event. Alice and Jasmine?
Actually, Neil, I had a question from earlier in the presentation. You mentioned if you have foreign nationals working for you and there was a change in the work circumstance where they are working from home. Was there something that you needed to do or an action you needed to take related to amending any forms or reporting because of that?
So the answer is, that's a great question. It really depends on which category the individual is here in the United States. So your foreign national workforce can be here in any number of different categories authorizing their employment. And each of those have a different answer to the question. Predominantly, the one that is most impacted is the H-1B program and the E-3s who are here through the treaties, and they're similar to the H-1 programs. Those have labor condition attestations where you have made a certification that the individual will be working at a specific location at a specific salary. If the individual is being moved in the same MSA, the same metropolitan statistical area, then you have to do a posting on that new location. And you have to update your public inspection folder. If the individual is moving out of the MSA, so they were working here in New Jersey and they went back to San Francisco because mom and dad are in San Francisco and we can work from home, that's a whole different MSA. You actually had to file an amended application. There were also a whole host of rules associated with those individuals who were handling their I-9s, because now you were doing mostly your I-9s remotely, and there are a whole bunch of rules associated with that. Individuals that would like to get our alerts, which go in detail as to what you're supposed to have done, certainly can either reach out to the organization or to us directly. We'd be happy to share that with them.
Okay, thank you.